what's the difference between a non-exclusive licensing agreement and an exclusive deal? Hi, I'm JD Houvener, patent attorney, owner here at Bold Patents Law Firm, and also the author of Bold Ideas, the Inventor's Guide to Patents. If you haven't heard that book or checked it out, click the link below. We've compiled the Inventor Kit for you to click that link and get access to the whole PDF of the book, as well as some really cool diagrams on patent searching, drafting, as well as your options for monetization down the road. Let's get into this. So the difference between patent licensing and patent sale, to start with, is licensing is where you, the inventor, you're the owner of a patent, or maybe even a pending patent application. You're giving up the rights, giving up your ability to prevent anyone else in the market and giving it to one or many people. And we'll talk about exclusive or non-exclusive in just a bit. I do want to differentiate sale first. When you sell your patent rights, you're giving up all your rights at once, meaning every single ability for you to prevent you from making, using, selling, or importing. All of that's going up to an individual person or entity, and you're done. So usually deals, especially with products that have not been built yet, tested, and you're pre-revenue, you're usually looking at a licensing deal. And so this question is great about the different options between an exclusive license and a non-exclusive licensing agreement. These are contracts. In contract law, there's tons up for negotiation, and there's no difference here with a licensing contract. There are four main rights, as I mentioned briefly before, with patent law. As soon as you get a patent granted, you are the owner of the patent rights and the claims, whether they're written or through drawn to a design patent. You have the ability to prevent anyone else in the whole country from making your invention, using your invention, selling your invention, and importing it here into the US. Now, I won't get into international perspectives just to keep things straightforward here. Now, each one of these four rights are yours to license, right? The contract, give out. And if you non-exclusively give out just one of them, let's say the right to make your invention, well, that might be the ability for manufacturers here in the US. You're saying many manufacturers, or at least more than more than one, are able to make your product. And so you're going to do a deal with, let's say, 3 different manufacturers. All right, that would be a non-exclusive licensing agreement because there's not one manufacturer that you're stuck with, if you will. So it's on you and maybe your attorneys to work with them to make sure that they are following whatever you've agreed to in that contract, whether that's a performance clause, right? They've agreed to make X number of widgets for you at certain quality and send them out by X date, right? Lots of different terms. The second one might be the right to sell your invention. You can say, you know what? I only want my product sold by, let's say, Target. And that's the retailer. Okay, so that contract is a licensing agreement and exclusive, meaning they're the only one able to sell your product. Although it's coming from 3 different manufacturers, you want it sold only through that one channel because they're giving you a great deal on your royalty rate, meaning the money that you can get each time your product is sold. So that's a negotiation, right? All those points can be negotiated, should be researched, and should be working with a licensing contracting attorney. All right, lots of other rights as well. We mentioned the rights to prevent import, or importing products into the US, as well as making, using, selling, using the invention. Sometimes using the invention is a right that you reserve as the inventor, because usually, let's just get over it, we're going to be still inventing. Inventors invent, and you're going to be working on version 2 of your product before you know it, and you want to have that what's called a license back. Even though, of course, allowing the licensee to use your product, maybe for development, putting packaging around it, or labeling, that type of thing. You want to be able to use and continue to innovate so that you can come back next year with version 2 and begin a new licensing agreement for that. So hope that helps understand a couple of big differences between exclusive and non-exclusive licensing. There's a few other aspects to get into. The coolest one I know of is that for an exclusive license, the licensee, the one that gets the license from you, the inventor, they are usually on the hook to help defend your patent. That's a really big important case because usually when there is infringement, it can be a very expensive and time-consuming process to go after infringers. So if you do an exclusive deal, that is one big benefit you can usually get into the contract if you negotiate well. All right, everybody, hope you enjoyed this episode. I'm JD Houvener, owner, founder, and patent attorney at Bold Patents Law Firm. Click the link below and get your copy of the Inventor Kit today. Go big, go bold.